You're welcome back. This is Newsfile. It's your most authoritative news analysis platform, and here on Newsfile, we put Ghana first. The standoff between the Speaker of Parliament and the President. We'll continue that discussion today too. We dealt with it last week here on this platform, and almost all my guests, the lawyers who were here last week, were unanimous, agreeing that the court has the power to bring forward all the processes that have been filed and to even deal with the cases with dispatch so that the matters will be resolved. Still here in the studio, Samuel Atacha is MP Abuakwa South and Chairman, Mines and Energy Committee of Parliament. Dr. Kwabena Donkor is MP Pro East and former Minister for Power. Doctor, you're a member of the committee, right?
Yes.
Right.
Senior member. Dr.
Justice Shrem Sai is Senior Lecturer Consultant, Senior Lecturer Constitutional Law, GIMPA Law School. Justice, thanks very much for making time to join us.
Thank you very much, Samson, and good morning to my learned senior and Dr. Kwabena Donkor, who are in the studio.
Right. So, there have been two cases that were filed, one filed in 2023 and another filed in 2024 in March against the anti-gay bill and the processes or whether or not it passes constitutional muster. There's one by Amanda Odoi, earlier filed in 2023, June or July, and there's one filed by Richard De La Sky, filed in March, on the 7th of March, or yes, that is it. And there are two applications for injunction in that matter pending. They were all filed on the 7th of March, 2024. The President had earlier intimated that because of the pendency of those suits, not injunction applications, he felt that he didn't have to take any step. Then the second suit was filed, and then the injunction application was also filed. And the presidency issued a statement explaining why it has refused to accept the bill from Parliament. On account of that, the Speaker of Parliament, Aban Bagwin, also, in what is an obvious tit for tat, decided that MPs who had been vetted will not be approved because Roxy Nelson Dafiamapo, an MP, also had issued a writ asking for a number of things, more particularly that the President, in his communication to the public, had indicated that certain ministers had been relieved of their post, and then he purported to reassign them without recourse to parliamentary vetting, and he insists that they must be brought to Parliament to be vetted. Ni Papo Samuel Ado, lawyer for Dafiamapo, filed an injunction on that matter, one on the 21st of March, another on the 25th of March. The 21st March one is what was dealt with on Thursday. And the 25th March injunction application was deemed not to be proper. So the injunction is gone. What should happen? Let's begin with you, Justice. But first, let's hear what Godfrey Dame had to say about the development.
Tamako does not understand the workings of the rules of court. An application for a rental of time for hearing of the matter comes in when you have time a certain or fixed time, and you seek to bring the date for it, that is when you are abridging the time, you are bringing it forward. Where no date has been fixed, it is absolutely the duty of the matter to cause the matter to be fixed for hearing. So I specifically wrote a letter to her ladyship and asked any date for hearing. That's a letter on record, as is done by all practitioners when they are sought. All practitioners who know the workings and rules of court. And indeed, I have done this many, many times. Even recently in the Supreme Court case 2011. That time, Edwin Tamaklo was my student in the Ghana School of Law. It's a matter of record. I applied for an expert hearing of this famous Vans for France matter. So clearly, when the LDC speak this way, it shows a total lack of understanding or total ignorance about the rules of court.
Right. So, as far as you're concerned and your knowledge of the law that you teach, did the Attorney General do anything wrong in writing to the Chief Justice asking for an expedited trial or hearing of the injunction application?
Yeah, thank you very much, Samson. The Attorney General did nothing wrong when he wrote a letter to the registrar or the Chief Justice to abridge the time for hearing the matter. But the question, to put the question that way, would also mean that we have left out some very fundamental, concerns or issues which need to be discussed or need to be considered. There's something called discretion in the Constitution of Ghana. Discretion is very essential to leadership. I mean, if you're in government or if you're a public official, you definitely need to have some discretion. Discretion is actually the essence of power. So anyone who has power necessarily must have discretion to go one way or the other. So that is the issue on discretion. However, the ultimate essence of law is certainty and predictability. So when, for example, we say the first law of physics or the law of that, what we are basically saying is that there must be, the thing is so certain that it should cut across circumstances and it should apply evenly across the board. So that is the fundamental essence of law. Now, the reason why I'm raising this issue is that the Attorney General definitely has a discretion to abridge or to cause a case, the time for hearing a case to be abridged. And he ought to do that by writing to the CJ or the registrar.
First of all, substantively, there was no time for the hearing. So was there anything to be abridged?
Well, I was going to go to that. And that would have to lead us to the changes in the practice in the Supreme Court. And you remember, I think later last year, there was a directive from the Chief Justice, which indicates that when you file a case, contrary to the previous practice, where you'll be given a specific date on the phase of your motion before the motion even goes out, this time around, we don't have dates on the processes. Rather, there is a note which is often attached indicating that the Chief Justice the registrar would issue a hearing notice. And the note, that statement itself is not clear.
Within 14 days upon service.
Yeah, upon service. And then it says upon request again. So the question is upon whose request, and how would the person who has issued the motion, know that there has been a service on the other party for him to make that request? And if it's supposed to happen within 14 days, then the notice itself is vague. But that is where I was talking about discretion and some of these directives. So the essence of law is certainty, and that's why we have something called constitutionalism. If you have a discretion to do something, the purpose of law is to, as much as possible, limit the discretion so that we don't have some of these things coming where discretion may be exercised capriciously, wrongly, or even vaguely. So what we seem to have here is that we have increased the discretion, the discretionary power that we are giving to, in the administration of justice, to the extent that previously, while both parties would automatically know the date of hearing, and then if someone wants it to be heard earlier than that date, will make a formal application to the court, which application will be served on both parties, and then the argument will be taken as to whether there should be an abridgment or not, and the two parties are present to discuss or argue that for the court to make an informed decision. Now, the current arrangement actually takes away any of these things. So a person will write a letter to the Chief Justice. The Chief Justice would listen to only that person's concern and either abridge the time or refuse the abridgment. And then at the end of the day, a date is fixed, which may or may not be convenient for the other party. And if it's unable to come to court, the case will be heard. So if we talk about whether the AG can do that or has the right or power to do that, indeed, he has the power to do that and is the right thing to do. However, we have created a system which basically is making it impossible for a hearing to be fair, which is fundamental to our jurisprudence, that whenever a decision is going to be taken, whenever a case is being heard, even every process filed in the case, whether the party is even concerned or not, should be served so that there will not be a situation where a decision will be taken.
So what's the problem?
In the absence of the
what's the problem? The Attorney General writes a letter to the court or to the Chief Justice or the Registrar asking that I want an expedited hearing of the application. Then a date is set for, that was Wednesday, the 27th. Now, when that date is set, all parties are notified about the Wednesday hearing, except that there was some problem with the plaintiff's service on the plaintiff. But as we know, if a bailiff comes to you, tries to serve a process, and you try to evade, once they drop it and you are seeing it, they drop it before you, it is good service. So what is the point here? You write a letter, but the date for the hearing is communicated to all the parties before the case is heard. Is that not it?
That is so.
So what's the problem?
What's your question again? What is the problem?
What's the problem? You raise questions of fairness.
Yeah, my question goes to, so what happened is as a result of the new regime of getting a date for processes in the Supreme Court. I mean, you would agree with me that if it were the old regime where the date would be printed on the process, then the AG would have filed an application for what? Abridgment of time. And you raised the issue that there was even no time. So how do you file an application for abridgment? That is exactly why the AG couldn't file an application for abridgment of time and had to what? Write a letter, because the new regime doesn't give you any basis to even make that kind of application for abridgment of time, because there's actually no time to abridge. So, and once the letter went, on a very good day, the determination of whether the abridgment should be granted, okay, must be subject to argument. Is that not so? I mean, is that not so? If you want to take a decision whether to abridge it, because we know that it should be within 14 days after service, okay? And within that 14 days, we are assuming that all the parties will know the day on which the process has been served, and they will start counting what? There are 14 days. What it means is that then the party would have to apply to the courts, to find out when the other party had been served. And that inquiry, you and I know, can take a couple of days. So what I'm saying is that the confusion happening now is not necessarily because of what the Attorney General did by writing a letter, and it's also not necessarily because the date has been determined and notice has been served. It is because of a bigger issue, which is creating a situation where there's very little, not hearing of both sides for a decision to abridge time to be taken. And you see, I'm making this point because most of the time we pick on specific instances without looking at the bigger, picture. So what I'm saying is that this problem would not have come up everywhere in the regime which gave both parties the opportunity to file for an abridgment, and the other party will be heard, an argument to be taken in respect of the abridgment. So that is the point I'm making, not necessarily to say the AG was right or wrong, or not necessarily because the date was given or notice was not given fairly. But this problem, you and I know, and I believe my senior in the studio, Honorable Attache, would agree that this situation will not happen if we were having the old regime in place. So I think it is time that we probably have to reconsider this, the new regime of filing thing. That is what I think the issue should be.
So, when you look at the process of injunction applications, the injunction application or the notice comes together with an affidavit and your arguments, what we call the statement of case. The opposing side will also file their facts in the affidavit and then file their arguments in the statement of case. Very often, judges will say, that is enough. I don't want to hear any more argument. I can give a decision. Is there a question of lack of fairness because Dafiamakpo and his lawyer were not in court?
No, I think the question is not lack of fairness because they were not in court. I mean, the court could have actually decided the motion without hearing any argument. I think that is the position of the law. The court could have looked at the affidavit evidence alone and make a decision.
Or without the motion being moved. It's a settled law that the judge can decide it.
Yeah, the court can decide even if the motion is not formally moved.
That's right.
And these days, we are even advised not to move it in terms of argument, just move it, by what? A formal, So that is the position of the law. The court could have decided that. But we would agree also that the issue about being present is now what is in dispute because the people the appellant or the applicant are saying that they were not aware. I mean, they are claiming they are not aware of the date. And even though the court was satisfied that they have been duly notified, my point is that once the other party is aware and has come, and that is why sometimes you would agree that a decision of the court will be set aside, that the other party is not given an opportunity to be heard. Now, after the case has been decided, assuming that what happened in court, there's now new evidence that the other party, that is the Fiameco, has not been properly served. You would agree that that would be a valid ground for vacating the decision of the court.
So,
right. I'm just saying that assuming.
Right. So my question so far is to come to the point where I'll ask you to educate the public. Was anything amiss in the application being determined and dismissed? Did something go wrong?
No, I mean, you cannot sit at home, right? And draw. I mean, the presumption is that once the court considered all this, then nothing has gone wrong. So in terms of the procedure that I know, in terms of all the things, my knowledge of the law, nothing has gone amiss as at what we have on the records of the court. That is the point I'm making.
Right.
But then the question is, you see, the question ought to be bigger than what we are limited to what the rules of court say. But we also know that administration of justice, as we say, justice must be seen to be done, not
manifestly
just done, but it must be seen to be done. Because when you administer justice in such a public interest manner, and it's raising legitimate concern about whether there was a fair hearing, the answer to that kind of objection is not necessarily to rely strictly on rule of law. That is why I began my submission by looking at a bigger issue than this.
Okay.
So, I mean, nothing is wrong as what has been done, but there are concerns which I think are legitimate based on what regimes we are running.
Okay. What will be your topmost pick on the concerns that have been raised? I'll not predict any one of them for you. Which will be your major concern in this case?
No, my major concern is that you see, and it has to do with the way the Attorney General is going about the issue, the matters. So, for example, it is within the Attorney General's discretion to decide which case to abridge, which case to abridge. So there are two cases. In both of the cases, he is defendant in case 1 and case 2. Now, the question is, what informed the Attorney General to choose case 2 in respect of which he asked for abridgment of time without doing the same in respect of what? Case 1. That obviously is a question which needs to be explained, because as I understand it, the Attorney General is not an Attorney General for, he's not a partisan Attorney General in terms of Attorney General is for the Republic. He represents all of us. In cases when Attorney General is even in court, he could be called upon to give his opinion on matters, and his words basically are also valued more than any other lawyer in the case. So, and that is based on the understanding that an Attorney General is a person who has the whole public interest, is the repository of the public interest as far as law is concerned. And that is why he's also the Minister of Justice. So the question that I would ask is, why would he choose to abridge one of the two cases when he is defendant in both? And both of them have, significant impact on administration of government, both in the legislature and in the executive. That is my concern in this.
I am Attorney General. There are 1,001 cases before me. I determine which one is of, pressing need to attend to. Why should I be explaining that to you? And don't we know that Parliament was suspended by the Speaker because of what he said was the Dafiamapo injunction? The fact, though, as I keep repeating, is that by the time the Speaker said there was an injunction, there was none. Why should he be explaining to you which of the cases he chooses to want to be heard quickly?
Well, it is not a question of the Attorney General explaining to us, but it's in respect of people, or be the people asking questions. And when, by the fact that he occupies a public office, when questions of this nature come up, I think there must be some element of explanation that, well, I chose case A to abridge, I abridge the time in respect of case A because of this and these factors, which are not present in respect of what? Case B. That is what we expect to hear, so that the public concerned that he's choosing the side of the debate unfairly or unreasonably would be laid to rest.
But the Attorney General advises the government. And the Attorney General knows where the President stands on the two matters. So was it not a matter of, consequence that he would want to do what the President puts premium on?
Yes, Samson, that's exactly the point. That's exactly the problem. That's exactly the problem that, the Attorney General wrote a letter to the Speaker a couple of days ago. And in the letter, what was he trying to do? He was trying to advise, Parliament on what ought to be done. And that, I think, because he considers it his duty to advise not just the executive, but also anything that affects the government as a whole, because he's the Minister of Justice. Now, the question is, why, if he knows where he stands, if the Attorney General knows where he stands and is proud of where he stands and want everybody to know that I stand with this side of the debate, I am more concerned about not having the bill in question passed. I'm more concerned about the President's interest as against Parliament's interest. Why was he writing the letter he wrote? Why was he seeking to advise the Speaker? Why was he advising the President in particular way? So it is these inconsistencies in his stance. In one way, he seems to represent the interests of the government, as a whole. When I say government, I mean all the arms of government as a whole. In another instance, he seems to be, in the same set of facts, he seems to be more interested in the side of the President than the other side of the debate. And this is what is making people ask these questions. That right. Is it Attorney General for all of us, or is Attorney General for one side?
So address this for me quickly, and then you hold on. I will return to you on a more substantive question, that we know the general principle of law on the effect of served applications for injunction. The general principle of law is that once served, you stop. You don't do anything to overreach the court. But don't you join the exception that is being canvassed and more vigorously by people like Oliver Barker-Vormawor about not using injunctions to stop the performance of a constitutional or statutory duty? But you will come to that later. Now I'm asking, would you say the NDC is justified in any way by attacking the Chief Justice and the courts the way they have done? That she's biased, literally, that she's doing the bidding of the NPP by not paying attention to the applications that were filed on the 7th of March, but rather dealing with the applications that were filed on the 21st and 25th, is it? Yeah?
So the question really is not whether you agree or not. I think the question should be whether you understand the position being taken as from, that is what the position that NDC, has taken. And that is why I began my submission by explaining that there is a more, there's a bigger issue, there's a bigger concern, which is, so the problem did not just come up, the problem is inextricably hooked with something which has nothing to do with this particular case. It is hooked up with something which is new, which has created or has widened discretion. So if you look at it from that perspective, then basically what I'm trying to say is to point out the fact that we need to administer justice in a more, comprehensive manner. And that clearly is an issue which we need to look at. And that is the point that I made earlier about.
Yeah, my question to you is, from where you sit, I don't want to read and repeat the statements in the NDC's release. Are they justified? Their basis was that 2 injunction applications were sitting before the court filed on the 7th of March. She ignored those and then decided rather to expedite hearing on those that were filed on the 21st and 25th. Therefore, she's exercising discretion capriciously. These are their words. Arbitrarily, she's being biased, and she's seeking to facilitate Akufo-Addo's agenda.
No, in this particular, case of this particular case, we've just explained that it is not the Chief Justice's, making. Chief Justice the registry gives timeline for cases. What we are looking at is an abridgment application or a letter of abridgment which has been brought by the Attorney General, which the Chief Justice has to act on. If there was no application for abridgment in respect of the other cases, I honestly do not see how the Chief Justice is supposed to, know the need for urgency and be able to abridge the time for that. And even if she did that, that would be that would even be capricious in the sense that then he's acting out of authority, because there's a rule, a general rule, that the matter will be brought within a certain amount of time. One person has applied for abridgment, which is before you would have to act on that particular abridgment. So if the Chief Justice acted on that abridgment and there was no application for abridgment from the other, and I'm using abridgment in a vague way, the letter, if there was no letter in respect of the others, I believe that then the Chief Justice would not even have the authority or a legitimate basis for bringing that forward.
Okay. Thank you. Hold on there for me now. Let me come to Atachi and begin with you.
Yeah.
Now, a very good friend of mine, and whom I practiced in chambers with some time ago, Kweku Agriolanes. He practices both in the UK and in Ghana. He wrote an article on Independence Day
Yes.
and said, Ghana's parliament has placed an independence bomb on the president's desk. That's the anti-gay bill. With the Supreme Court being called on to, hopefully, act on the disposal unit.
That's very interesting, you know, because you see, we are supposed to function by law. Anything less than that is disaster and aberration. This constitutional dispensation, we should look at it from the perspective of supremacy of law, not the pleasures of men and how they feel. So, if something is supposed to be done by the president, by operation of law, you should look at the law, the parameters of the law, and act upon it. Because you can't have a president acting unconstitutional and be comfortable. And so is everybody in the situation, the speaker and even the judiciary. So that's how I see what is unfolding. And I find it very, very, very interesting and how we need to uphold the Constitution and the supremacy of law for our own peace. If not, it could be very, very chaotic. That's how the little response I'll say to this.
We all clamor for speedy disposal of suits. And we say, even our system does not encourage investment because suits takes forever.
Yes.
And people have heard me refer many times to this small family land matter that took 40 odd years to determine. And in 2014, when the Supreme Court eventually finished that case, Chief Justice Wood described it as a parody of justice.
Precisely.
But will it be fair in the circumstances we find ourselves where one party says, I want the case to be dealt with quickly, and you are sending notice to the one who actually brought the matter, and you are calling them today to come tomorrow? Shouldn't you give them a bit of time?
Well, they should be given time if and only if, with the greatest of respect, they've not placed before them their documents. That is all I want to say. You see, let's respect the new dispensation. The new dispensation, with the greatest respect, is not the case that the presence of a human being before a court of law will improve the documents duly filed and the law.
Sometimes substantially it does.
Well, if and only if there's necessity for the judges to say that, Samson, with the greatest respect, can you address us on this point?
That's right.
But they can dispense with all that, and it's just the paper arguments they'll look at and deal with it. So this is what I'm seeing, because in those days that we didn't have this new dispensation, you need to be physically present and move a motion and argue and urge upon the court all the authorities you believe should make you win your case.
And we are told Peter Ajete stood on his feet for 2 days.
Yes.
Arguing one matter.
Precisely.
And the court entertained him. Today, they'll give you 30 minutes, even if you are lucky.
If you are lucky. In fact, less. But right now, the statement of case that you stress, I want to drum it home because the general public should know. They didn't let my lawyer speak. And that is why I've been given an unfair treatment in the court. You see, they want to curtail the tendencies of lawyers speaking for so long, rather than reducing their thoughts together with the law in very simple terms called the statement of case. So if my good friend who is complaining about he being short-served, and it depends on the discretion of the judges, that look, in order to give him time, he's been short-served. Can we give him 2 days to return? I don't see how that could hurt a fly. I don't see how that could challenge the processes. And I didn't see the emergency that, if the case was not determined now, something serious will happen. So for me, in order to expand the parameters of fairness, I would say, well, the gentleman is alleging that he's been short-served. Can we give him, 2 days to come back to us? That will curtail some of these, accusations
in the courtroom. it would appear that the judges may have been angered
Yes.
by the testimony of the bailiff.
I heard so.
Because the bailiff was asked, you were supposed to have served this party to come to court. Have you served? He said, I went to the offices of Ado and Ado legal attorneys, lawyers for Dafiamapo. When I got there, I was told that the lawyer says we shouldn't accept any service on this case.
Yes.
So he dumped it, dropped it, and left. We know now from CCTV footage with an audio that the bailiff was untruthful. But at the time, the court did not have the opportunity to know the other side.
Precisely.
So they were unhappy that a lawyer would treat a Supreme Court process like that.
Yes.
And the Attorney General actually called on the court to look at that matter as misconduct on the part of the lawyer.
Yes.
And refer the lawyer for punishment.
Yes. So if you look at it from that perspective, it was a bit emotive in not giving the judge, the lawyer, the opportunity to come. And the facts are showing that indeed it is not the fault of the lawyer. But let me tell you that if you pay regard to all the, if you like, paradigm shift that Dr. Muhammad Bawumia wants to bring to bear in this entire country called Ghana, going digital. Yeah, you don't need a bailiff now to bring to the attention of anybody that, look, come to court. Because the system could just go via,
Electronically.
Electronically. And then you have it. You can even have the processes on your phone, and the proof of service and the rest of it will be curtailed. But be that as it may, I will say one thing that the NDC should bear in mind. The presence of the lawyer will not improve upon the law by this current dispensation. They can even say that, look, nobody should come to court. Don't waste your energies. We will give them a date for the ruling. And the rules have changed.
Yeah.
So we should come to terms with that. But I am even surprised that people are not appreciating the move of the Attorney General. A most egregious error has been committed. No dispute about it. That the whole House of Parliament should be suspended by reason of the fact that they shouldn't do business. There's an injunction. It turned out that there was no injunction. Therefore, the confusion that what my good friend, Honorable Dafiamapo, had filed impinges on the House looking at the issues of the ministerial nominees who have been vetted for approval is a humongous situation.
Ministerial nominees who have been vetted for approval.
Yes.
And which category does not include those he has concerns about.
Yes.
Because those he has concerns about, he wants the court to compel the president to bring them for vetting.
Precisely.
The president is not bringing them for vetting.
Yes. So therefore, if you have a serious Attorney General, and I believe we have one, who went into the situation and advised the Speaker on the matter. I have the letter here. I don't believe we should go through all these matters. Now look, it is not the case that there was any injunction pending. The Speaker was trying to be law-abiding in a vacuum. There was nothing pending. And even if anything was pending, if you pay regard to what my good brother filed, I have it here, the issues are materially different if you look at his reliefs. So I don't see why anybody should fall there.
Except that his reliefs included an interlocutory injunction.
Yes.
Against the vetting of even those who do not fall in the category that he was against.
The absurdity is monstrous, to be very honest. That if the substance of your case, should invent another area which is not related to your case and frustrate it, then the mischief should be punishable. That's how I see it. You see, because you can't play games with the court. And by extension, you cannot use your technical skills, to even deceive Parliament. It's a very, very serious matter. And if the Attorney General wants to, if you like, remedy the wrongs, and he wants the case heard expeditiously, and fairness and the rest of it you can talk about.
Okay.
But essentially, I am of the view that the new dispensation does not require the presence of a lawyer for the case to be improved.
So you say, for example, which is also correct,
Yes.
that they could simply have issued the hearing notice to them and they will appear, but they will not make any arguments.
At all.
You just appear to hear your ruling.
That's what it can be.
So why didn't they take this posture in the circumstance, but rather heard argument from Thaddeus Sori, representing the Speaker, and also Godfrey Dame?
You see, I am of the view that it was a bit of a charged atmosphere and it was a bit emotive because they saw the dropping of the lawyer refusing to accept service as an affront to the dignity of the courts. Albeit, the evidence showed up that that was not the case. So that is what happens.
But judges must have the composure not to allow such emotions.
I agree with you 100%. The same argument I was making for my very revered speaker, that the letter emanating from the office of the president should not drive him to that position in which some of these matters occurred. So when we come to places of dignity and responsibility, we should manage our emotions well because the consequence...
Let's speak to the non-lawyer amongst us. And people are equally interested in the non-legal aspects of this matter. Yes.
Certainly.
Yeah. Finally, from the NDC perspective, and I'm a proud member of the NDC, we had a situation, first of all, on the e-levy, where people went to court. The president, notwithstanding
the pendency of the application for injunction,
went ahead and assented to the e-levy. Remember, e-levy was so divisive.
Very much.
So he did that. So for us, that's a precedent. Then it comes to this anti-gay legislation. The same president, if it had been a different president, it would have even been slightly different, says there's pendency of this in court, and therefore I'm not going to even receive it. And for me, the president was wrong. No matter the legal gymnastics you people will conjure, he was wrong not to receive the letter. If the transmitter had been received, then he has options. I can then state that in a letter to Parliament that because of this and that, I'm not in a position. Or even refer to a Council of State as provided for under the Constitution. But to refuse. And the tone of that letter from his secretary just annoyed all of us, whether this or MPP. In fact, all MPs I spoke to, including MPP MPs, were so angry with the tone of the letter, the wording of the letter. And you see...
Why are you people surprised about that? Because in Parliament, the two sides who must guard the dignity and power of Parliament, which is almost sovereign, you have diluted it and allowed the presidency at all times, not in this regime, to supersede even Parliament. The president has the votes of not everybody. In Parliament is represented all Ghanaians. So you have cheapened it.
Well, the nature of our adversarial politics has led to that, and it is not the best. I'm the first to concede it is not the best. But most importantly, as a people, as a nation, remember we are a nation building. We must learn from our traditions. And the secretary to the president, in my opinion, has led the president down big time. Why do I say this? The president, as the two of you have just agreed, is human. He can be emotive. The Supreme Court has displayed that tendency. and my chairman is also attributing the same tendency to the speaker. So let's say the president has been emotive. You are his chief advisor as his secretary. What do? You stay that document over. You do not write a letter. The president may even use worse words. But it is your duty. And it is not by error that quite often they prefer diplomats. KD Osei, Kufuor secretary, was a diplomat. To handle these emotions. In our tradition, let me use the Asante-Hene for example. When Asante-Hene sits in state, adjudicating over a matter, traditional matter, and his temper begins to rise, you hear the, I don't want to call them servants, the courtiers behind him, they start singing his praises. What does that do? It signifies that he should calm down. You don't expose your leader because we are human. So the secretary of the president should have found a way of toning down whatever the president's anger and transmit a letter that is decorous to Parliament. But if anybody who reads that letter gets angry, you are literally daring Parliament. And the clerk to Parliament is a constitutional officer.
That's right.
Performing his constitutional duty. And you sit there, your appointment is administrative and at best under the Presidential Office Act.
Subject to your notice, not approval.
And then you do that to Parliament. So for the NDC, that was an affront. But more importantly, you see, the difficulty that puts the president, in my opinion, 80 to 95% of the Ghanaian population are in favor of that bill. It might have implications that a few of us...
Parliament actually approved it by unanimous decision.
It might have implications that the executive arm will know. For example, it has impact on World Bank funding. It doesn't affect IMF. It has implications. So how do you handle that? That is where diplomacy, tact, and respect comes in.
Samson,
Diplomacy, tact, and respect.
Samson, I have a little issue. Okay.
Okay, so can you let me? Then, if you take the e-levy, so for us as NDC, we are a political party. We are representing a part of the country. And our membership cuts across all classes, all ethnicities.
Right.
And then if we see these lawyers, particularly the Attorney General, who is supposed to be the Attorney General of the Republic, speak for all of us, behave in a way that seems partisan, then of course we'll have a right to express our opinion.
Right. The Supreme Court has actually had cause to suggest that on certain matters where the Attorney General is still the principal legal advisor to whichever state entity, that state entity can have their own lawyer, because it appears sometimes that the interests may not coincide. Now, Atacha, is it significant that it took the NDC getting this angry about the circumstance before the AG discloses to the public that I am the one who made the application to the court, I'm the one who wrote to the CJ? Because it appears that originally they were under the impression that it was a court's decision so motu on its own motion that they brought the matter forward. Does it change anything regarding the tone of their letter where they said the CJ was biased and seeking to do the bidding of the party?
You see, because the CJ didn't engineer the hearing of the plaint.
Yes, that's what I'm saying.
Yes.
If at the time
Yes.
they were saying this,
Yes.
because they did not have the benefit that it was Godfrey Dami who had written to request for it.
Yes, it should. And it is very, very important that the allegation against the Chief Justice was misplaced, and we should accept it as it is. But let me also tell you something which is very painful for me, being a member of Parliament. If we are not careful, we reduce statecraft to, if you like, the kindergarten level of tit for tat, going to do postmortems about past behaviors and the rest of it. Granted, the president's secretary's letter was terrible. You see, the matured way of handling what is very bad is to not to say, oh, is that what you've done? I'll do the same. So Samson, I'm very, very sad about this tit for tat. It's not good for statecraft.
Okay.
Understand? There's a way that would have looked at it, and then we would have avoided.
The speaker's lawyers,
yes,
have also written
Yes.
to the court.
Yes.
They are written to the registrar of the court,
yes,
asking for an expedited hearing of the injunctions that have been pending since 7th of March.
It is their right to do. Understand? If you are a lawyer and you believe that the process is not being followed, or you believe that there's a necessity for some matters to be heard, you have the right to do. So if you look at an attorney general who has seen that there's been a major error in Parliament, and if it's not corrected, it's going to hurt the running of the government of President Akufo-Addo, and it takes proactive initiatives, how do you fault him for that? And I won't stop any lawyer who wants a matter heard expeditiously.
There's an issue about trust in the judiciary. Should it be minded about that issue when he's taking decisions in politically sensitive, public interest matters like this? How can this be cured so that we don't have a situation where people are thinking, this CJ was brought in to do this and she appears to be doing it? Yes, Atacha.
Yes, I believe that is very critical. You see, because when we have a public-centered matter, not a private one, you see, that is to say, it is not just the professionalism of what we are doing which matters, but how it resonates with the generality of the public. So that trust dimension is so important, so that people have confidence in the judiciary that somebody is not here to do the pleasure of the president. So therefore, whatever it takes to ensure that the matter is very, very clear and is well understood, it should be done. But in this particular case, with the greatest of respect, I can't see how anybody can fault the CJ who didn't engineer the hearing of the application and the rest of it. Because the CJ would have been very derelict in her duty not to have responded to what was coming from the Attorney General. The only problem which has happened is the short service, which I will say as a lawyer and coming to terms with the new dispensation, that no matter how you say it, and my brother was short-served, although he filed the process, it will not detract from the fact that even you might not attend court, insofar as all the processes are before the court now. And this is what the practice has become.
Let me state this about the CJ. It is important I state this.
Quickly.
The CJ put herself in this. I happen to have been at a public function at the Church of Pentecost Convention grounds when former President John Mahama was introduced. The CJ was there. Her body posture. When no. This is so important. No. It is so important. I'm not in a law court. I'm on a political program. It's so important. And it went viral. And so for us as NDC, the body language, the way she made the face, and it's all over the place.
The CJ is human.
Yes.
Through the election petition.
Listen.
You heard the comments that the former president and the NDC made. Unanimous FC and all of that.
I'm making a very specific case. So at a public function, when the CJ does that to our leader, our flag bearer, of course, her subsequent rulings will be seen in that way.
I'm saying, granted that this is actually what happened. And
I was there.
It is your interpretation.
I can produce those.
I'm not saying I haven't seen that.
Yes.
It is your interpretation of her demeanor of posture. But she may explain to you that that is not what you may have misunderstood or misrepresented her. Okay? All right. Now, quickly, I understand the signatures are being collected to force the House to resume, to get back and approve this minister.
Let me correct you.
Yes.
It is not to force. It is within our rules.
It is under the Constitution.
We have exercised that and our standing.
When you are requisitioning something,
Yes.
you are forcing things.
No.
It's
It is the right of MP.
language.
It is the right of MP.
Okay, let's not argue over language. Yes.
For a recall
Yes.
of Parliament.
It's a constitutional provision of Article 1123.
That's correct.
Yeah, that it has become very important that in view of what has happened, that there was a monumental error which brought about the non-consideration of the ministerial nominations and how eventually it could sabotage the running of the government. Why don't we converge and look at it? So I am of the humble view that it is very, very necessary.
You can't wait until Parliament actually returns.
Well, you don't want to stall the running of the government. Look at the number of ministers that are market time. I mean, and we want results. So the full complement of the government will aid, the running of the state.
There are 24 ministers who have been vetted and deputy ministers
It's not
who
a
have
joke.
been vetted and waiting approval.
It is not a
There are
joke.
7 ministries that are without a substantive minister as
It's not
we
a
speak.
joke. And therefore, everybody who believes in running the government, which will also inure to the benefit of Ghana, should be interested that we come back quickly. And even sometimes in very, very critical situations, and even in holidays, Parliament said to take quality decisions that will help the nation.
Okay.
Anybody who is fighting that we don't come and sit is stalling the progress of work of the government. And it shouldn't be the case. And it's a
And
bad
that is
precedent.
costly. That is
It's
costly.
a very expensive. And we'll set a bad precedent that eventually, when you are in power, some people might just erase this ghost called tit for tat, which I believe
Okay.
is not good for
When are you normally expected to return
Well,
from this break?
we would have come back probably late April or early May. Because as a
Late April or early May?
because it's not been
Okay.
formally
right.
communicated
Yes.
Okay.
of return.
Yes.
So
the
for-
NDC has used this tool before to requisition a sitting.
No, you see, it is within our rules.
That's
It's
correct.
fair game.
Nobody is saying it's wrong.
Any
Yeah.
group of MPs,
Yeah.
a certain minimum number, and it's a one-item recall by our
it's
standing orders.
15%.
Yes.
15% of
And
members
you
of
can only
Parliament
come to do one
request a
business.
meeting. Yeah.
Okay,
By
thank you.
understanding of-
Now let me end with Justice Stremsai and Doc. I was asking earlier that we should look at the very important question. Listen to Dominic Ayene and then respond to that question I had put to you earlier. Whether we should not give sufficient education on what ought to be the exception of the general rule affecting the performance of a constitutional or statutory duty. Listen to Dominic Ayene.
If you want a court to give an expedited hearing, there is something we call an application for abridgment of time. You file that, you serve it on the other party, okay? And then they can prepare themselves and come to court on the abridged date, okay? You don't go Nicodemously to the registrar of the court or to the CJ, who is the chief administrator of the judiciary, to ask for the thing to be abridged. Then the registry puts the case, abridges time for you, all right, and then serves notice on the other parties to come to court immediately. That is unethical.
How?
It's grossly unethical. Okay, you are subverting the rules, of procedure in your favor, and that is all. It doesn't matter that you're the Attorney General of the Republic. You need to apply, for abridgment of time and serve notice on the lawyer on the other side, because the lawyer on the other side should not be taken by surprise.
For where he was talking about the questioning of performance of constitutional duty vis-a-vis the effect of service of application for injunction. Quickly. Hello, Justice.
Yeah. Yeah, so the video that was played was not in respect of what...
Yes, that's what I'm saying. So let's go straight to that question about the need to appreciate the exception to the rule.
Yes, so I think I hold that view as well, that, you know, when the Constitution gives a command for something to be done and is given a timeline within which the thing ought to be done, I think in as much as we all agree that the court, on the circumstances of the case, may grant an injunction either on application, even so much that is by itself, I think there must be a reason why the framers of the Constitution, you know, would give that kind of command and give a time frame. Now, the issue then is, if we apply the general rule of a person being restrained, immediately an interlocutory injunction is filed until the determination of the application for interlocutory injunction. If we apply the general rule, then we should take steps again to make provision for some of the matters to be determined as soon as practicable. No, so it will result in total misadministration of government, or total running down of government, or halt in government, if we proceed along this line. I mean, the line where someone files interlocutory application for an injunction, and then everyone must stop pending the determination of the matter, regardless of when the application will be moved and when it will be heard. And that, I think, is an obvious flaw in the argument that we keep making, that when the person files an application, everything must stop. I mean, Samson, let me give you a typical example. You are Joy FM, you are running public service, right? You are running a radio station, a TV station. Assuming I have an issue with you, and as part of my case in court, I apply for an interlocutory injunction, and in my relief, I'm saying that to stop transmission. And you have to stop your transmission pending the determination of the case, regardless of whether I even have any merit or whether there's even lawful basis and all that. And that will really be a problem, unless there is an additional requirement that when you file an injunction application, an interlocutory injunction application, you should be ready, or provisions to be made for the motion to be moved immediately. Okay. Otherwise, I don't see the merit in the application of the general rule to all parties. So all matters. And I think that is where we need to start thinking about. It's not enough. Sometimes you see, the courts have made decisions on a particular case in a particular, circumstance concerning some definite facts or set of facts. And when the court makes that decision and makes, statements, it is difficult for us to accept that that statement is meant to apply to all situations. So I have not seen anywhere where any court has ruled, that when a constitution gives you a command, you can, once you file the motion, then once you file the motion, then the person who has a command to perform within a certain period of time should stop performing the command. All right. And I think the cases that we have been referring to as authorities for this principle, we're dealing with certain facts that are not on all fours with this. And I think my understanding of stare decisis tells me that when a court gives states a general position in a case, it must be deemed to be in connection with facts that are similar or that are almost on all fours with the same case. Okay. So I am looking for a day when this, and I think these cases present a very good opportunity for the Supreme Court to actually consider all these matters and give us a more clear, position going forward. Okay. Thank you very much, Justice Shremsai. But some will say that is the reason in the rules about injunction, granting of interlocutory injunction, something we have overlooked is the undertaking. That if you say we should stop broadcasting, you give an undertaking and you pay for the cost. If we were stopped and then eventually you lost, you pay for the cost of everything that we have lost. I'm sorry, but we are run out of time. We have to move on. We have to move on. We are run out of time, and thank you very much. And also, in fact, the president, if the injunction pending now is determined, it doesn't change his mind, because before the case, Richard Sky filed the case, he had intimated that
Richard Sky had filed a case, which was wrong though.
Yes.
And said that he will wait until the case is determined. So not only the injunction application. Thank you all very much. Samuel Atacha is MP Abuakwa South and Chairman Mines and Energy Committee of Parliament. Dr. Kwabena Donko is MP Pru. He's a former Minister for Power. He also belongs to this committee. Dr. Justice Stremsai is Senior Lecturer, Constitutional Law, Gimpa Law School. Joining us shortly is Dr. Yao Osei Educhum.